Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about Chapter 13 bankruptcy, which is reorganization under the Bankruptcy Code. Joining me once again is my co-host, Jesse Barrientos. Jesse, how you doing?
Good, Dave. How about yourself?
I'm doing well, Jesse.
Awesome.
You know, whether things are rolling in this country or whether they're going downhill, there's always a need for the Chapter 13, the reorganization, they find a way to pay back and get a fresh start to a certain extent. So let's jump right in. What is Chapter 13 bankruptcy?
Chapter 13 is a consolidation, essentially, is what it is. And I also want to mention there are a lot of companies that provide consolidation services, so-called, and my experience with them haven't been so good. Only because Chapter 13, right, is sanctioned by federal law. It has teeth into it. When you do the other consolidation, it's purely voluntary. They don't have to follow through with the agreement. But in a Chapter 13, they're bound by what the law is. So it's your consolidation or partial repayment of your debt. Could be secured or unsecured. We talk about secured debt being debt that's secured with property, like a house or an automobile, something of that nature, or unsecured, which would be credit cards, medical bills, those kinds of things.
Okay, so what happens in a Chapter 13? How does it work?
Oh, in a Chapter 13, what happens is that all of your assets kind of just go in one place. That's what you call your estate. And depending upon what those assets are, the bankruptcy trustee kind of makes, pays off the secured and unsecured. With the Chapter 13, you have to be able to pay off 100% of your secured debt and as little as 10%, all the way up to 100% of your unsecured debt within 36 or 60 months, so 3 or 5 years. That's what they call the plan. So there's the term of the plan. It could be any place in between there, depending upon what you have left after your allowable expenses. And everything's protected. Generally, in a successful Chapter 13, any mortgage arrears, any cars that you own, because that's all included, not lease cars, but cars that you own, is included in that. And so after that term, you come out pretty good because you don't have to worry about the penalties and the interest and those kinds of things. But everything's paid for. So, your car now is paid for, and you've essentially paid back most of your debt. Just again, it depends upon what you have left after that.
When would somebody want to file a Chapter 13?
Well, to save a car or to save a house in arrears, we have a lot of mortgage issues going on. Sometimes people just need to kind of get a foothold on things. Maybe they haven't been the best at managing their money, and I find that there's a lot of people. It really doesn't matter. I've seen people that come in and all different types of income levels and have difficulty. With the people who have more money, it's just just the bigger difficulty because they've been spending more. But a lot of times people, they're in arrears. Maybe they haven't been able to pay for the past 6 months, and so there's no way they can pay current, but they can't pay that mortgage arrears because maybe somebody got sick, maybe somebody broke a leg, or had some type of employment situation, lost a job or changed jobs or switched. There's just could be a whole bunch of different things, and the mortgage company won't accept it when you're behind. They want, they're going to start to try to accelerate the loan and ask for everything. So you can't just, okay, well, here, I'll take this amount for my current mortgage and tack the other stuff someplace else. So a lot of times they won't let you do that. Same is true with the car. You need your car to go to work. You can't go out there and buy a new car. And so that will also, once you file your Chapter 13, you'll be able to kind of straighten that away too, because that's a secured debt and that creditor is going to be paid.
So in a nutshell, you're basically telling the mortgage company, you're going to get paid,
right?
But you're going to get paid through this reorganization. And your auto, you're telling them you're going to get paid as well. Maybe not the full amount, but you're going to get paid under this plan of reorganization. and therefore I get to keep both items as long as I follow through on my plan. Is that correct?
Exactly right. So again, you could save your house or your car in distress. Dave, what are the pre-filing requirements for Chapter 13?
Well, the first thing you have to do for Chapter 13, you have to provide your most recent federal 4 years of federal tax returns.
4 years. Why 4 years?
Well, legislature felt that under Chapter 13 you should have to provide 4. That's not the case with other chapters of the Bankruptcy Code, but Chapter 13 is different. They want 4 years of federal tax returns. So if you have not filed and you needed to file, you're going to have to get that done before you're eligible to file a Chapter 13.
Does the bankruptcy trustee, actually scrutinize your tax returns?
They do. And in fact, if you do not file the tax returns or show proof of filing within 46 days of your Chapter 13 bankruptcy case being filed, your case will automatically be dismissed. Therefore, a lot of attorneys want to make sure they see the 4 years of tax returns before they go ahead and file the case, because there's nothing worse than attorneys spending all kinds of time and energy on a bankruptcy case that's going to be dead on arrival in 46 days if the client hasn't really filed those federal returns. So that's the first requirement. The second requirement is proof of income for the last 60 days. This could be paycheck stubs, Social Security income, unemployment benefits, rental income, any source of income, even royalties or dividends that trustee wants to see, because that's all part of your estate. And then the last requirement is the same as other chapters of the Bankruptcy Code. You must take a credit counseling session. It's a 1-hour session done on the phone, online, or in person. Costs about $15. It takes about an hour. And you'll have to go through this process of listening to information about income and expenses and budgeting to be eligible to file for Chapter 13.
So it's a precursor. So I can't, what happens if I file my bankruptcy and then an hour later I take the class?
Well, there's some case law now that says as long as you take that credit counseling on the same day as the filing, you're okay. However, I would play it safe and make sure you complete the credit counseling and get your certificate first, because it is time-stamped. Make sure you get your certificate first, then file your Chapter 13.
So if I filed the Chapter 13 and then I took the class the next day, what happens?
Well, the trustee is going to bring a motion to dismiss for ineligibility because you did not have the proper documentation before the filing. Also, a creditor can bring that motion too. So if you're trying to save a home from foreclosure and you file before you've actually completed that credit counseling, the creditor can move to have your case thrown out.
So it's important to speak with a seasoned bankruptcy attorney.
Exactly. Chapter 13 is not something you want to try alone.
Or to do on your own. There's a lot of places to navigate through that. What is the chapter, or rather, what is the automatic stay, and is it applicable in a Chapter 13? I know we talked on one of our other shows with respect to Chapter 7. We talked about the automatic stay, but is it applicable here in a Chapter 13 as well?
It is. The automatic stay is what you get upon filing, which basically tells creditors they cannot take certain collection actions. The automatic stay is everything the client is looking for. It stops the foreclosure dead in its tracks. As long as a sheriff's sale hasn't happened, you can save the house. It stops an auto repossession. If you file the bankruptcy case in the morning and the repo man comes in the afternoon to hook your car, you've got the automatic stay, you've got the protection, you've got your case number.
What if they yank it anyway?
Well, if they yank it anyway, you can get it back under the Thompson case. There is some issue as to whether or not the car can be given back if there's no stay or if there's not adequate protection payments, but they can't hold the car hostage based on failure to pay or failure to show proof of insurance. They have to give the car back. It's compulsory. And then if you don't make payments or if you don't provide proof of insurance, they can then petition the court to repossess the vehicle legally.
But they have to do that through the court. Let me ask you one question that occurred to me. Apparently, sometimes when people buy a car, people who don't have the best credit, there's a device that's in the car that allows the dealer to shut it down. So what happens if if I file my bankruptcy and I've got my stay, and I mean, does that prohibit them from shutting that down too?
It does. You own that vehicle until such time that it's sold at an auction. So if any time prior to the sale of the vehicle, you file a Chapter 13, under the Thompson case, that vehicle must be returned to you, provided there's a stay in place. Now, there's some other issues that go along with it. moving forward that you want to make sure you have things in place, but you will be able to protect that vehicle. It's your property still. Until the court determines that it's no longer your property or that the creditor has the right to repossess it legally, you will get that vehicle back, if not permanently, at least temporarily.
What kind of percentage do you pay back in a Chapter 13 consolidation?
It's going to depend on a number of factors, including your assets, your liabilities, your income, and your expenses, and whether or not you filed a Chapter 13 and got a discharge or a Chapter 7 in the last several years. In most cases, it's going to be the difference between your income and your expenses, which is known as your disposable income. So typically, if you have a couple hundred available, that's what the creditors are going to get per month over a 3 to 5 year period, and whatever percentage that winds up being is what it is.
But you still have to have enough through that duration, the 36 or 60 months, in order to pay your secured creditors 100% and your unsecured, as little as 10 cents on the dollar?
Right, but what I never want to do is I never want to quote a percentage, because in reality, I don't know who's going to file a proof of claim and who's going to be part of the bankruptcy case. If you're a client who completes the bankruptcy and a creditor, unsecured creditor, did not file a proof of claim to be part of the payout, then that debt is eliminated in its entirety.
In a Chapter 13.
Right. So you might actually pay back more than 10% of those that filed claims, but in essence, you might be paying 10% or less of your total debt, depending on who files a proof of claim.
So if you file a Chapter 13 and no one files a proof of claim, then those debts are just discharged completely.
Exactly. And we've seen cases where 30 to 40% of the debt does not file a proof of claim.
But then that also increases the amount of money that's available to pay back those other creditors or unsecured creditors who have filed their proof of claim.
Right.
So that's what gets tweaked.
Right. Now, I'm not in the habit of giving out creditor advice, but obviously if you receive a bankruptcy Chapter 13 notice, it would behoove you to file a proof of claim, because you are going to share in the pot and maybe even share to a greater extent if your other brethren creditors don't bother to file a claim.
Do they always pay out? I mean, I can tell you, I've had experiences where we've had judgment for attorney's fees. I filed a proof of claim, nothing.
Well, it depends. Did the debtor complete the repayment plan? Did the debtor pay into the plan for 3 to 5 years? More likely than not, that debtor's case was dismissed before it completed, because approximately 15% of Chapter 13 is complete. And
only 15%?
About that. I mean, it's a very difficult case. You're asking someone who is struggling financially,
Right.
who wants to get back on their feet and has good intentions, to repay over a 3 to 5 year period. Well, remember, things happen. Job loss,
Right, that's tough.
illness, injury, divorce, overspending in other areas, which prevent a person from being able to make that consistent Chapter 13 plan payment. So it's a real problem going forward.
Well, you mentioned the plan payment. How do I go about paying the trustees? So assume now we've gone through the numbers and we know what my disposable income is. So, and by the way, that's pretty lean, right? I mean, there's nothing else built in that budget. I mean, there's nothing for entertainment or anything else. I'm going to be living lean for that period of time.
Yeah, well, you should be living lean, because you're depriving your creditors and making them wait 3 to 5 years. So the bankruptcy court doesn't want you living high on the hog, having steak and lobster every weekend, while your creditors are waiting for 10 cents on the dollar 3 to 5 years from now. So that's the theory there. You have to live within your means and go by IRS budgeted guidelines. So you can't live high on the hog. You're really going to be living, like you said, lean. But that's for fairness of the whole process.
So how do I pay the trustee? Do I send him a check, money order, or how does that work?
Well, if you're gainfully employed and you're working for an employer, then I'm going to mandate payroll control. And that's where the money comes directly out of your payroll check to the trustee.
Does it have to come out?
It has to come out through my office. I'm not going to do a case if you're not going to go on payroll control, because that basically tells me you don't have a desire to really make your case work. If the money comes out of your check, then you know your Chapter 13 plan payment's going to be secure and that's going to work.
Because it's going to come out automatically.
Right.
But it's not, I mean, that's the way to make sure that someone is successful. However, but that's not a requirement. So there are other folks out there who don't do that.
Right. If you're self-employed, if you're on Social Security, if you receive rental income or any other income unlike an employer, then there's no way to have it come out of your check. So you'll have to make voluntary payments to the trustee in the form of either a money order or a cashier's check, and it must be mailed every month on time for the next 3 to 5 years. Quite a task.
That's quite a task. Your office, Dave, you also do the first plan payment as well, do you not?
What I like to do in many cases is get the first plan payment that's going to go to the trustee up front. The reason for this is it's good faith. It shows the trustee when you go to meet him that you've already got one payment in the till. You're showing that you have the ability to pay, and it also softens the creditor objections to a certain extent. Someone's not going to allege bad faith if you already can show that you have the ability to pay.
And it takes probably at least a couple weeks or more, right, to set up the payroll deductions.
That's the biggest problem with Chapter 13 when people are on payroll control. The payroll doesn't always kick in very fast.
Mm-hmm.
The payroll department doesn't always forward the money to the trustee quickly. So it's good to have the debtor or client make one payment on their own. So there's one already flowing through. That way, by the time the payroll kicks in, they haven't missed a payment, because the first payment's due within 30 days of filing. And believe me, those 30 days can run pretty quick.
Oh, yeah.
And it doesn't give a lot of time for the payroll order to get signed by the judge, get to the payroll department, get turned over, and sent to the trustee. And remember, if you can't make your first payment,
Then
how are you going to make a
right.
3 to 5 year payment plan? Let's
yeah,
be
your
real.
very first one,
Yeah.
sure.
Let me ask you this, Jesse. Do creditors object to your plan for reorganization, or do they just accept it?
You know, it depends on the creditor. Sometimes they object. Essentially, and we talked about this, which is similar in Chapter 7. It's a 341 meeting. It's essentially the same meeting of creditors, but this is a meeting with the trustee to approve the plan. And I've seen some trustees, for example, they want to maximize what it is. So let's say, for example, that part of the money that's coming out, okay, is voluntary contributions to your pension, all right? Well, unless it's what they call a 100% plan, which is where your creditors get paid back 100%, your unsecured creditors for that duration, because there's enough money for that, unless it's a situation like that, I've seen where the trustee is going to tell you to stop that until the bankruptcy, the Chapter 13 plan duration is done. So they're going to tweak it. They're going to look at little things like that. Now, of course, everybody wants what, Dave? They want to get paid. They
Yes.
always want to be first in line, but there are certain priority claims that that you have. So sometimes creditors do object to that specific plan.
Does someone get to keep all of their property when they're in a Chapter 13, or do they have to give up some property in exchange for this reorganization?
Typically, they get to keep all of their property. I suppose there have been some instances, and I think I was referring to that before, where you have people that are all levels, people low wage earners and really high wage earners, and when you get to the top of the echelon or someplace, if somebody's got 12 cars, yeah, you can keep it, but if there's an issue and we're talking about that might raise an eyebrow from the trustee. But yeah, that's the whole point of a Chapter 13, that you get to keep everything, because in essence you're paying your creditors back.
But this is also the opportunity where you can say, I can't afford this house, I'm going to surrender it in the plan, or I can't afford this vehicle, I'm way upside down, I'm going to give it up in the plan and just continue to reorganize my other debts. You have that election.
You can certainly do that. And if you're going to get out of the house, there's a foreclosure pending, there's no way you're going to be able to pay kind of that off. That would put you into Chapter 13 for some other things, which maybe you wouldn't have been required before, because again, remember, you have to pay back your secured creditors 100%. And so if your election is to give up the home that you owe an extra $100,000 on, okay, well, you wouldn't have been able to do that if that was included in the plan, and so you can give that up. Or I suppose that during the plan period, you could also convert it or amend it to a Chapter 7. If things change for you, if all of a sudden now you've lost your job or something happens and puts you in a position where you can't make those plan payments. But they can be adjusted, can they not, Dave?
They can. If your income changes, if your expenses change, if there's a substantial change in your financial circumstances, you can bring a motion to amend the plan. Now, this has to be set out on notice. All the creditors will receive notice. You have to propose a new plan to the court, and you have to prove that that's a valid plan based on your income.
But generally, Dave, right, very few people are going to come into your office and say, hey, Mr. Siegel, I'm making a whole bunch more money a month here, and I want to pay more. Usually it's the other way around, isn't it?
It's usually the other way around, but every once in a while the trustee will see your ongoing tax return, and if there's an incredible increase in income, the trustee might actually bring a motion to dismiss if you don't kick up the percentage to the unsecured creditors.
So you have to keep your eye on that, or an inheritance or something of that nature.
Right. Well, an inheritance I think you can leave separate, but if your income goes up to the point where your disposable goes up significantly, the trustee could bring an action, but typically they don't.
What happens if, because it's going to get lean living during this time, what happens if I need to get credit am I going to be able, if I'm locked in to this plan for 3 years or 5 years, and probably shouldn't, the greatest idea, but I need credit, Dave, help me out.
Well, you're not going to get general credit for credit cards or things like that, but what you will see is a case where someone has a vehicle in a bankruptcy, Chapter 13, and the vehicle becomes in disrepair where it cannot run. That person needs transportation to get to their job so they can pay for their Chapter 13. So in that case, what we'll do is we'll have them go scope out a vehicle. They'll get the make, the model, the approximate amount of financing and the interest rate, almost like a good faith estimate. And then we will bring a motion to incur credit before the court. It takes about 3 to 4 weeks. And we're basically saying to the court, we need to purchase this vehicle. It's at a low rate, low dollar amount per month. We have the ability now to do it, and we need it to reorganize. And most likely the court will grant that as long as the vehicle is reasonable, the monthly payment is low, and the interest rate is not high.
But it's going to be outside of the plan, is it?
It is going to be outside of the plan.
So how is a dealer going to extend credit to me when I'm in a bankruptcy?
Well, the dealer knows if you don't make the payment, they can hook the vehicle and sell it at auction. So they're not
because
really...
it's not included in the Chapter 13.
It's not included in the 13, and it's a secured item. So if you can't make a payment, they'll repossess it. They'll sell it at auction. They haven't lost everything. They're going to be able to recover. And they can still come after you for the deficiency because it's a post-petition or after filing acquired debt.
So in some instances, it actually puts the dealer in a little bit better position.
Right. Dealers have no problem lending to a Chapter 13 bankruptcy client as long as there's court approval. Without court approval, they can't do it. But court approval is relatively easy as long as the parties are reasonable in terms of their purchase.
Well, Dave, what happens if we're in this plan here for a couple of years and let's just say that I've inherited some money, and you know what? I never wanted to do a bankruptcy in the first place. I just didn't have much of a choice. But now I find myself in a position where, hey, guess what? I can pay everybody off.
If your case is paying back 100% anyway, then you can go ahead and pay it off, just like you're prepaying a mortgage or paying off your vehicle. If, however, you're in a 10% or a 20% plan, then you just want to keep making that regular payment. You don't want to tip your hand that you have all this available money, because some trustees and some judges will say, okay, now you can pay a higher percentage because you came into money. So it's better just to keep making the monthly payment, trickle it in. Eventually your case is going to complete. It can't go more than 5 years or 60 months. So eventually it's going to come to an end. Just keep making the payment, especially if you're paying less than 100% back to your unsecured creditors.
But can I get out of a case before it concludes, before that 60th month?
Well, you can certainly get out of the case. You can decide you want to dismiss it. But if you dismiss your case, you're going to be back in the same position you were pre-petition. Creditors can come after you. The mortgage company can foreclose. The auto lender can repo. So really, there's no benefit to dismissing your case unless you become ill or you lose your job or for some other reason you just can't continue.
Well, let's take the situation that we were talking about before about getting credit. So, if we're getting credit for an automobile, all right? So let's say that, it becomes difficult for me because of the reasons you said. Can I dismiss my 13 and then refile it?
You can.
And include that automobile. That before was post-petition.
Yes, if you dismiss your case and then refile, you are basically starting over. That new filing date controls. However, if you have a case dismissed within a year of refiling, then you must bring a motion to extend the automatic stay to get the full bankruptcy protection.
Within how long?
If a case is dismissed within 1 year of filing a second case, you have to bring a motion to extend the automatic stay. Otherwise, that stay expires after 30 days. Some judges have felt that it extends to, the stay applies to the bankruptcy estate. Others have said it only applies to the debtor personally and not to the property. So you want to be very careful about dismissing and refiling. Plus you have another filing fee, another 341 meeting, another confirmation
So
hearing.
it's just starting all over again, but in some circumstances it might be advisable. That's why each situation is different, and you need to talk to somebody who can help you out there. What is it, other than paying the stuff back, what is it going to cost me in terms of attorney's fees, court filing fees? And I'm just guessing that the trustee is going to have to be paid.
Right. The way it works right now, and this is forever changing, the filing fee for a Chapter 13, anywhere in the country, the court cost is $281. The attorney's fees are going to vary by jurisdiction. But here in the Northern District of Illinois, the judges have adopted what's known as a model retention agreement, which provides for a flat fee of $4,000 over the life of the case to your attorney. Now this means no matter what happens in your case, whether it's a simple case or the most difficult case, your attorney's fees under that model retention agreement are capped at $4,000, and they're paid out over the life of the plan. So it's going to be affordable for you because it's going to be based on your budget, and the attorney is going to get paid out of your trustee payment.
As long as it concludes, as long as you conclude your case, or you finish it up, correct?
Right. Well, actually, your attorney might get paid quicker depending on how much your plan payment is. But the bottom line is, a lot of attorneys will do the case for $281 down, which is just the court cost, and then accept their attorney's fees over the life of the case. So it really gives someone struggling an opportunity to get their foot in the door, get the Chapter 13 going, get the protection from their creditors, get the benefit of the automatic stay, and pay their creditor as it's rolling.
Well, Dave, what happens? I mean, you had mentioned before about payroll control where the money's coming out. So if I didn't do payroll control, would my employer find out? Obviously, if I'm doing payroll control, they're going to know. But if I didn't want to do that?
Well, your employer only needs to find out if you're either on payroll control or if there's a garnishment pending, and therefore we need to send proof of your Chapter 13 bankruptcy filing to your employer to stop the garnishment. Otherwise, your employer does not need to know. Your neighbors don't need to know. Your friends don't need to know. You can kind of keep this covert. The only way someone would know is if they're either your employer and we need to stop a garnishment, they're a creditor in your case and they have to receive notice, or 3, they're a nosy neighbor, they go down to the bankruptcy court and type into your name into the database, which is not highly likely. So for all practical purposes, you are going to know about your bankruptcy, but nobody else is.
So I have some measure of confidentiality, even though it's a matter of public record.
You do, but also you need to weigh too as a debtor. Let's say someone needs to know. Let's say you have a friend who lent you money and they have to be listed on your bankruptcy petition. You have to weigh the benefit of getting out of debt or getting into this reorganization plan versus not having a person know about your bankruptcy. This is federal law. This is your right to reorganize. I wouldn't be so concerned about everybody knowing about it. Be concerned about what kind of relief that you're going to get under this chapter.
But I have to list everything, right? So let's say I owe my friend Dan $500 and my friend Mark $1,000.
Yes, you need to list everybody you owe money to, even a family member, even a friend.
Even if it's not in writing.
Even if it's not in writing. That's all we have time for. Jesse, thanks for joining me.
You bet, Dave.
This has been Legal Action. We've been talking about Chapter 13, reorganization under the Bankruptcy Code. We'll see you next time. Bye-bye.